So I'm very happy to welcome everybody to our GAPLA online talk for June. And I have to say, we're in month 12 of our online talks. So I'm happy to say that. And just, yeah, and I believe we have a couple of people who might not know what GAPLA is. It's actually the German-Australian Pacific Lawyers Association. And we provide a platform for lawyers from jurisdictions from German-speaking countries, but also from Australasian jurisdictions to connect and exchange on legal topics and the like. And today we will speak about distribution law in Germany and Australia. And we have as our speakers Dennis Groh from the German law firm LLR, as you can see on the screen, or should see on the screen. Laschet Legolotz Rechtsanwälte from Cologne. And Dennis has been a member of GAPLA already for a very long time, and more than 10 years, I would say.
Yes.
And yeah, and his connection to Australia started during his practical legal training when he was in Sydney for a stage, and he also wrote a doctoral thesis on a German-Australian topic. And let me just quickly look here, and it's, oh gee, that's the Competition Act, right?
The
So
Spam
the
Act.
comparative,
Spam Act.
the Spam Act, oh sorry, there you go, on the Spam Act, very current. And well, he's now a lawyer in Germany, practicing in commercial law and with a focus on distribution law. Anything to add, Dennis, or are you happy with that?
Oh, that's fine. Okay, you could
Very
add
good.
intellectual property law, but we are talking about today, so let's go with that.
That's why. And then, of course, we got our lovely board member, but also very long-standing member, Michael Kobras, who's dialing in from Sydney from the home office because he's in one of the affected suburbs. And Michael is a partner with SchweizerKobras, and I believe has been one of the very first lawyers in the 90s to have a dual qualification in Australia and Germany, and has been practicing ever since then, and is practicing in commercial law, advising German clients, especially with a focus on entering the Australian market.
That's correct.
Hope you're happy. Yeah, very good. So then, Dennis, I hand over to you.
Yeah, thank you very much, Juliana, for your kind words. And again, welcome to today's GAPLA talk. I'm very pleased to tell you something about the different legal forms of distribution in Germany. Of course, it's not possible to explain all of German distribution law just in 30 minutes. Therefore, the main purpose of this is just to give you a short overview about the different possibilities and, of course, about their advantages and disadvantages. And let's just jump right into it. Well, what does distribution actually mean? That's actually quite simple and not surprising for you. You have a product which could be goods or services. You can also distribute services, of course. And you have a manufacturer who wants to distribute that product to the end customer. And we have here the symbol for the manufacturer. You have to memorize that because I will refer to it in the following. This is this symbol here, factory, and we have the customer here. And the manufacturer distributes its goods by means of distribution. Now, let's have a look at what forms of distribution there are in general. And I like to divide distribution into two categories: direct distribution and indirect distribution. Now, direct distribution means that the manufacturer sells its product directly to the end customer. So there's no middleman in between. There's a direct contractual relationship between the manufacturer and the end customer. Whereas in indirect distribution, there's a middleman in between. And this is the guy with the briefcase here. Yeah. You can easily imagine how he has a vacuum cleaner in his briefcase, which he wants to sell to the end customer. So that's the middleman. You have to memorize the guy with the briefcase because he stands for the middleman in indirect distribution. In direct distribution, there are essentially two options. One is e-commerce, and the second one is distribution through stores on site. So that's direct distribution. In indirect distribution, our guy with the briefcase can appear in three different ways. He could be a commercial agent. He could be a reseller or authorized dealer. We will learn later what are the differences between those two guys. And he could be a franchisee. So those are the 4 forms of distribution we are going to look at today. Why only 4? Because I'm not going to sell anything about stores, because experience shows that normally foreign undertakings, they don't want to use stores because it's simply too expensive. And so they refer on e-commerce or on forms of indirect distribution. And we only have 30 minutes, so I'm just talking about e-commerce and those 3 forms of indirect distribution. Let's jump into it. Start with e-commerce. It's a form of direct distribution, and of course all of you memorized the symbols, so you know we have here the manufacturer and we have our end customer. And now the manufacturer distributes its products by, for example, email or web shops to the end customer. And the important thing to notice is that we have only one purchase contract between the manufacturer and the end customer. So that's the reason why we are talking about direct distribution. And we will see later on in forms of indirect distribution that we could have more purchase contracts in such constellations. All right. Now, what are the advantages and disadvantages of e-commerce? The first, in my opinion, the biggest advantage of e-commerce is that if you have a proper English language web shop, you could sell easily your products worldwide, because people from all over the planet could log in your web shop and buy your goods. Another important point is that you have full control over the distribution and the prices of the product. So the manufacturer decides what is offered in his shop, when it is offered, and at what price it is offered. And we will see later on that this isn't always the case in forms of indirect distribution. So that's a big advantage here. And also the costs of e-commerce are manageable because you don't need sales staff and you don't need stores on site, meaning in Germany. So that's another big advantage. And another important point is that you have a direct contractual relationship between the manufacturer and the end customer, and therefore you are able to build your own customer base as a manufacturer, and this could be very important. Again, this is something which is not naturally in forms of indirect distribution. Sometimes you are not able to establish your own customer base. But there are a number of disadvantages. And the first one is that in Germany, you have to comply with numerous legal requirements if you are starting a web shop in Germany. And anyone who has ever checked the web store according to German law knows that that's not fun at all, because you have to comply with numerous information and labeling obligations. You have to comply with data protection, the European General Data Protection Regulation, which could be honestly a pain in the ass. And also we have numerous consumer protection regulation, and consumers have a 14-day right of withdrawal in B2C relationships. And therefore, if you have a web shop in Germany, there's a high risk of formal warnings. So now it's necessary, I think, to explain the concept of formal warnings, because I know there's nothing comparable in most foreign legal systems, especially not in Australia. In most countries, violations of, for example, information and labeling obligations are punished by public authorities. I think in Australia, it's the ACCC. Yeah, I think it's the ACCC who does this in Australia. In Germany, this is different. Here, the control is left to the competitors. They have their own right of action, and they can issue formal warnings if they think that someone is not behaving right. And without going into detail at this point, I can say that those formal warnings can be very expensive, and they are very common. There are lawyers in Germany who do nothing else than issue formal warnings. So if you are thinking about starting an online shop in Germany, I strongly advise that you look for serious counsel, because this really could be a problem. And last but not least, there might be some products which are not perfect for selling via e-commerce, for example, machinery and cars. So those are the advantages and disadvantages of the selling via internet. Now let's have a look at the first form of indirect distribution. This is the commercial agent, which is regulated in section 84 of the German Commercial Code. And I've put down here a little definition. So the commercial agent is a self-employed intermediary who is constantly entrusted with the task of procuring contracts. And as a remuneration, the commercial agent receives the performance-based commission. Okay. Now let's take a closer look at the commercial agent. My professor at the university used to say that the commercial agent is the darling of German commercial law because he enjoys special legal protection. And I have often seen that foreign companies do not know what they are getting into with those commercial agents. Now let's have a look. Again, we have our manufacturer, of course, who wants to distribute the products to the end customer. This time, however, here appears our guy with the briefcase. And the manufacturer gets into an agency agreement with the guy with the briefcase, with the commercial agent. And based on this agency agreement, the agent now tries to convince the customer of the product. He's trying to persuade the end customer to buy this beautiful vacuum cleaner, which he has in his briefcase. And if he's successful, he earns his commission. So that's the main purpose here. And also it's important to note that the purchase contract is concluded between the manufacturer here and the end customer. Now, there are also special commercial agents, special agents, the so-called district agents. The district agent is an agent to whom is assigned a specific district by the manufacturer, and he earns his commission for all businesses concluded by the manufacturer in this district. And that's very important to note. The district agent's commission does not depend on whether he has actively arranged the contract with the customer. The district agent always gets his share. So foreign companies should be very cautious about appointing district agents because this could quickly become very expensive. Well, let's have a look at the advantages and disadvantages of commercial agents. First, the advantages. Since the sales contract or the purchase contract is concluded between the manufacturer and the end customer, the manufacturer again has full control over prices and can build his own customer base. So that's exactly the same with direct distribution. And this is because the manufacturer gets into an own relationship with the customer. At the same time, however, the manufacturer saves unnecessary costs because he only has to pay the commission to the commercial agent if there is a business transaction concluded. So there are no fixed costs as you have, for example, with employees. And also, you could very good control your commercial agents by means of instructions. However, not to the same extent as with an employee, but you are able to control commercial agents. And this is the reason why distribution through agents is so tempting for foreign companies, because you have no fixed cost at the beginning. You just send your agent to work, and if he's successful, he gets his commission. But, and this is often overlooked, and this is the most important message of this presentation, there's a number of legal risks that you need to be aware of if you are dealing with commercial agents. The first disadvantage is not so unusual. It's logical because you have a direct relationship between the manufacturer and the customer, and therefore all warranty claims are aimed to the manufacturer. Yeah, and this is different if you are dealing with reseller. Then you don't have the problem with warranty claims because then the end customer has to face to the reseller and not to the manufacturer. The second disadvantage is very important. I cannot highlight this enough. Under German law, the commercial agent is entitled to a compensation claim, which is regulated in section 89b of the German Commercial Code. What does it mean? Upon termination of the contractual relationship between the manufacturer and the commercial agent is entitled to this compensation claim. So this claim always exists if the manufacturer terminates the contract properly, or if the commercial agent himself terminates the contract with just good cause. And what are we talking about? The calculation of this compensation claim is very complex, but as a rule of thumb, you can assume that this compensation amounts to approximately 1 year's average commission calculated from the last 5 years. So you could easily imagine that there's often a higher six-figure amount at stake. And another important message is that under German law, this right to the compensation cannot be contractually excluded and it cannot be avoided. So if you are dealing with commercial agents in Germany, you will always have the problem of this compensation claim. So that's the reason why I put this nice skull here just next to the compensation claim, that you never forget it.
Dennis,
Right.
just a quick insertion here, because that's quite a typical thing for German law, I think. So Michael, is there anything like this compensation claim in Australia?
No, unless you actually have expressly agreed to in a contract, there's nothing, which also in some ways makes Australian distributors or agents address contractual or the distribution approach a bit differently, because they know they could get any lose the distributorship. So it's not such an incentive to invest too much in building up a distribution network for a distributor in Australia, unless he has a long-term contract which cannot easily be terminated. But that right per se does not exist at all.
Just another note at this point, this compensation claim goes back to an European guideline, Richtlinie, and therefore it's not just in Germany, but in most countries in Europe, you have this problem. So if you are dealing with commercial agents in Europe, you generally have the problem of compensation claims. And another problem is that the commercial agent has extensive control rights. So the commercial agent can at any time and without any reason demand a so-called book extract from the manufacturer. And this book extract must represent a picture of all customer relationships of the manufacturer with the customer. Just because, so that the commercial agent can check whether commission has been withheld from him. So in this book extract, you have to show all your customers, you have to show all businesses which you conclude with your customers, you have to show what kind of goods you are selling to them, you have to show at what price you sell the goods to the customers. And I can tell you from experience, this again is a pain in the ass, because it's very, very time consuming and very, very expensive. So it's another big problem if you're dealing with commercial agents. And last but not least,
Dennis, just one quick question on that. Is that right does that right only exist for as long as the agency agreement exists, or even afterwards? I'm just wondering if that would assist an agent to calculate the compensation under Section 89B.
Yes, it exists already. Exists after the relationship as well. But normally, if the contractual relationship is terminated, let's say from the manufacturer, that would be the point in time where the district agent wants to know and wants to have the book statement and the extract of the books, because then he wants to know if he gets some more commission, and also he needed to calculate his compensation claim. And that's the reason why normally the extract of the books is the agent asks for the book statement during the contractual relationship.
Yes, I just going back to the 89B claim. It's quite unusual in Australia, and often very surprising, because it's not a claim for loss or damages as you would usually expect. It's a claim that goes beyond that. It's as I understand, it's actually a claim to compensate for the benefits that the principal will receive as a result of the work of the commercial agent. So it's quite outrageous for Australian lawyers.
That's absolutely right. It's a compensation for the customer base, which the agent built for the manufacturer, and therefore he gets the compensation claim. So you're absolutely right. It has nothing to do with damages. It's a compensation. And as you know, as you told us, most of the foreign companies doesn't know anything about compensation claims, and that's always a problem when they get away of it. And finally, we have statutory termination periods, which are extended depending on the term of the contract up to 6 months. So in the first year, you can terminate your agent with a period of just 1 month. And from the 5th year onwards, it is 6 months. And again, you cannot change this in contract. It's statutory and you cannot change it. Now let's have a look at the reason.
If I say this again, this would not exist in Australia. You either have contractually agreed what your notice period is, which can be anything, can be 5 minutes if you want to. But the other thing is, even if you have not agreed on a term, an indefinite contract can be terminated always on reasonable notice. So even if you have nothing in there, there is no guarantee for a distributor or an agent that there will be a long period just because he has been let's say he has been acting as an agent for a very long time. Doesn't give you a long basis. The reasonableness is actually determined by reference to how long does it actually take to wind down the relationship. And typically it is, okay, well, you know, there's still stuff, goods on the ship. So you should be able to sell those first, but it might be a 3 months period if he's lucky. It might not even be that. Yeah.
Okay, thank you, Michael. Yeah, as I said, the commercial agent, he's the darling of German commercial law, and that's the reason why he's protected so much in many different ways. But now let's move to the reseller. And again, I have a little definition down here. The reseller, he purchased the contract products from the manufacturer in its own name and for its own account. And then in the second step, he resells the products to the customer, again, in its own name and for its own account. And if the reseller is heavily integrated into the sales structure by means of a contract, then he's referred to as an authorized dealer. And he doesn't get the commission like the commercial agent, but he gets a discount on the manufacturer's price list, and therefore he has his own margin. But what does this mean in concrete terms? Again, we have the factory, which stands for the manufacturer and the end customer. And since we are in indirect forms of distribution, here's our guy with the briefcase. But this time, the manufacturer concludes a contract with the reseller, the dealer agreement, and based on this dealer agreement, there is a purchase contract conducted between the two of them. And in a second step, then the reseller sells the product to the end customer. And this is a decisive difference to the commercial agent. Unlike the commercial agent, the reseller does not arrange a contract between the manufacturer and the end customer, but he buys the product from the manufacturer himself, and then in the second step, resells the product independently to the end customer. And therefore, we have two purchase contracts, which is very important to understand, because this is the decisive difference from the reseller to the commercial agents. And we can see this in the advantages and disadvantages. One big advantage if you are using resellers is that the sales risk of the products is transferred to the reseller. So the manufacturer doesn't have to worry anymore about the products. He does not have to take the goods back if the reseller, for example, is not successful in selling them. That's the problem of the reseller, not the problem of the manufacturer anymore. And another big advantage is that resellers are always commercial entities, which means that less strict legal rules apply under German law. For example, the warranty can be shortened, you can limit the liability, and all of this wouldn't be possible if you are in direct distribution and you are selling your goods directly to end customers, to consumers. And also the information and labeling obligation are significantly lower than in B2C business. And there are no warranty claims by the end customer against the manufacturer, because the customer only has its contract with the reseller. So if there's any problem with the product, he has to go to the reseller and not to the manufacturer.
Can I just jump in there? But that wouldn't apply to product liability claims, because you have as a customer a direct claim against the manufacturer, don't you?
Yes, if you have a guarantee, if you have a product with a guarantee, then you can face
No, sorry. If there's a product liability case, gewährleist Produkthaftung.
Hmm.
You still have those direct.
Yes, there is Produkthaftung, but only in certain cases, and only for if you have you cannot get damages every time on those matters. So normally the customer would then go to his to the reseller, because there he have the Gewährleistungsansprüche, which are very strong under German law, and it would be much easier for the customer to go to the reseller.
Yeah.
Okay. All right. Another advantage is that you have no fixed cost as with an employee. You have no commission as with a commercial agent. You just get the price for the goods you are selling to the reseller. But no advantage without a disadvantage. And one disadvantage is that you must be aware that the resellers are completely free to set their own prices. And this is because of European antitrust law, TFEU. This is a treaty on the functioning of the European Union. And Article 101 prohibits the manufacturer from influencing the reseller's final price. So the reseller is completely free in setting his own prices. And this is a fact that bothers many manufacturers, because they want to prevent products from being sold at too low a price. The same applies for the question of to who the reseller sells to. The manufacturer cannot influence this either. And another important point is that the customers are the customers of the reseller, and they are not the customers of the manufacturer. And therefore, you are not able to establish a known customer base if you're using resellers, because all the customers are customers of the resellers. And this fact leads many manufacturers down a very dangerous path. And again, I cannot highlight this enough, because this is very important and very unknown to most foreign companies and also to many lawyers here in Germany. For many years now, the German Federal Court of Justice has had a very strict case law, according to which it applies the strict law for commercial agents to resellers. And this is an analogous application of the commercial agency law. And this always happens when two conditions are met. The first one is that the reseller has to be closely integrated into the sales structure. And the second is that there's an obligation to transfer the customer base to the manufacturer. If those two conditions are met, then the Federal Court of Justice would apply the strict regulations for commercial agents for the resellers. And therefore, you have to be very, very careful when drafting reseller contracts in Germany. But for example, if you write in your contract that at the end of the contract, the reseller has to transfer customer data to the manufacturer, or you hide this some way. If you say, for example, that the customers have to fill out warranty cards, and that those warranty cards then are forwarded to the manufacturer, and the manufacturer gets the customer data in this way, then you will always have the problem of the analogous application. And again, this is very unknown and very, very dangerous, because, as I told you, this compensation claim, 89B of the German Commercial Act, this would apply then for resellers. And last but not least, final point, the Federal Court of Justice considers very long notice periods when a reseller has made major investments for the distribution contract. And then there could be notice periods of even 1 year and longer. Okay, now let's have a look at the franchisee, and I can be brief at this, because I came to this later. let's first look at the definition for the franchisee. The franchisee, like the reseller, he also purchases products from the manufacturer, the franchisor, in its own name and in its own account. So there's a direct relationship between the franchisee and the franchisor. And then he sells the products to the end customer. But in addition to the reseller, the franchisee uses the franchisor's brand, his concept and know-how. And in return, he pays a franchise fee and a sales license. So again, we have the manufacturer and our guy with a briefcase, and the two of them get into a franchise agreement. And the franchisee then purchases the product from the manufacturer, and in a second step, he sells them to the end customer. And I've put a little burger here and a soft drink because, as you might know, most of the franchise systems are, for example, McDonald's, Subways, those are all franchise systems. Now, what are the advantages and the disadvantages? I can be brief about this too, because since the franchisee, like the reseller, buys and sells in his own name, the advantages and disadvantages are very similar to the reseller. So those are exactly the same advantages that you have with resellers. However, there are a few differences. Franchise systems leads to the fact that the brand of the manufacturer is used very strongly in the targeted country, for example, in Germany. And this is an advantage for the manufacturer in terms of trademark law. You might know that in Germany and in Europe as well, if you have a trademark registered, you are obliged to use it. If you don't use it, anyone can cancel the trademark or can apply for cancellation of the trademark. And therefore, you have to use your trademark in Germany in Europe. And you can do this via your franchisees. And that's a big advantage. And also, franchise systems are very interesting for startups because you need little initiative and you can take over a functioning concept. You don't have to bother about any of this. You can just start. And also through franchise manuals, the manufacturer can give the franchisee very strong guidelines and control the franchisee. This is also a very big advantage. But again, no advantage without disadvantage. And the first one is that the implementation of a franchise system is very expensive. The manufacturer faces high initial costs for the development and establishment of the brand, for the establishment of the know-how, and as well for the documentation of the franchise manual. And also, if you have started your franchise system, you have high administrative costs due to training and support and to control of your franchisees. And you also have an obligation to advertise if you have a franchise system. Another point is black sheep matters. What does this mean? If you have a bad franchisee and your brand can be seriously damaged, some of you might remember, some of the German attendees might remember that a few years ago in Germany, there was a large Subway franchisee who ignored the hygiene standards demanded by the franchisor. And there was a huge media outcry because there was moldy food in the stores, and this was serious damage for the brand. And this is a problem which you have if you use franchisees and allow them to use your trademarks. And last but not least, again, very, very dangerous. The same as with the resellers, we have also the problem of the analogous application of the commercial agency law on the franchisee. And this analogous application occurs very often because franchisees are usually very closely integrated in the distribution structure. So the first condition is usually met because this is part of the franchise system to integrate the franchisee in your structure. And if then the franchisee is obliged to transfer the customer base to the manufacturer, to the franchisor, then you are in the analogous application of the commercial agency law. Just have a look at the watch. Yeah, it's perfect because we are nearly done.
Just wanted to say yes.
yes. Okay.
Do you have any last words? Because otherwise,
I was a little over time here, so if you have any questions that we can't answer now due to lack of time, please feel free to contact me. You find my contact details here. I also invite you to connect with me on LinkedIn. so we can stay in touch on Twitter. Thank you very much, and that was it from my side.
From the German side, and that's exactly what I mean to take now. I hope the attendees are still there, still have a couple more minutes, because of course there's also the Australian side. So Michael, I understand in our pre-talk you said, oh, it's very similar where the legal forms of distribution are concerned, but maybe you have a couple of comments where it is not so similar, and we spoke already about that compensation claim.
Yeah.
And I just want to pick up one comment that Dennis made. He said the commercial agent is a darling of German commercial law. Is there a darling of Australian commercial law?
No, there's no darling. I think if I just say, well, the structure, of course, is in principle the same, and the advantages and disadvantages that Dennis described are very similar too. There's not that compensation claim, but that's not everything, but the control and not control over the dealings. Generally, when clients come to me, I advise them have a distributorship, or what Dennis describes as a dealership, in preference to an agency, because from overseas it's a bit harder to ascertain the financial soundness of your customers if you use an agent, because that's your responsibility. And what Dennis described as the advantage of having a reseller or a dealer is, or you sell to him, you only have to be certain of his creditworthiness, but not of the end customer's financial position. That's one point. I think what is probably the most important point for every distributor from Germany, or from every principal from Germany to know in Australia, is retention of title is not effective in Australia unless it is registered. This is a change that came in about almost 10 years ago, and I still find clients who find themselves with losing property because they entered into a distribution relationship or an agency relationship so many years ago and did not check the law and the changes to the law. i.e., I supply a multi-million-dollar machinery to a customer in Australia, and he just has paid the deposit and then he goes bust. If I have not registered my interest, I will just have lost property to my equipment. I think this is a point that is obviously easily overlooked. So a retention of title clause in your contract does not help you. Doesn't help you. Doesn't help you in a case of liquidation insolvency. It's not Konkursfest. There's a few points in Australian competition law which also have to be taken into account. There is a similar point that Dennis raised. There's a resale price maintenance provision in the Competition and Consumer Act, which prohibits enforcing fixed prices on your distributor, as in resale prices. There's also, if you enter into exclusive distribution agreements, you have to be careful as well, because they can be also a problem for competition law. However, only if you have such a dominating market position that there's basically no major competitor in the local market where that's the problem. Yeah, there's one more point I want to make out. Dennis was talking about trademarks and the protection. If I do distribution agreements or agency agreements, I have always a provision in there which permits the distributor, the Australian distributor, to use the trademarks. I mean, that's obvious. There's one provision that uses the trademark, that he does not get any right and title to the trademarks, and that even if he registers similar trademarks, that they are registered on trust for the principal. So one point is that you protect yourself against an abuse of your trademarks. But the other point is that if you do not give a license to your distributor will use the trademarks in its own name, and he will be generating a reputation and a goodwill in respect of the trademarks, and you're not using them in Australia. If you're not active in the market except through a distributor, you have to give them a license to make their use your use of the mark. And I had this as a problem as well, that some distributors register marks in competition, sometimes during the relationship, sometimes towards the end to cause problems. And unless you have regulated that, that's also a very, very dangerous point. That's basically everything I want to say this, because otherwise we are just going on forever. Because
thank you for keeping it short, very thoughtful of you, and thanks for those really insightful comments. And we have one question from Anne, and she asks what the relationship between EU competition law and overseas distribution is. If the manufacturer is in Germany and the reseller is an Australian incorporated entity and the distribution agreement is made under Australian law, to what extent is the manufacturer still bound by EU competition law? So Dennis, would you like to give it a try? And then if there is an Australian component, Michael, you can also think about it.
Yes, I think we have to differ between competition law and antitrust law. In Germany, those are mixed together. Even if you are an agreement made under Australian law, you are still bound to, of course, to European and German antitrust law. So you cannot, for example, say to your reseller that you are, you cannot influence the reseller, for example, and say him to at what price he has to resell the products. So if you do this and it has an impact on the German market or an impact on the European market, then you will always get problems with European and German antitrust law. To competition law, as we are talking about, for example, labeling obligations or information obligations, those apply even if you choose Australian law, but this then would be a problem of your reseller or not your problem. But if you are using an agent, then you are getting into contractual relationship with the end customer, and then of course you have to comply with all German competition law, for example, labeling obligation, information obligation, and under German law you cannot make a choice of law which is bad for German customers. German customers will always be handled under German law. German end customers, consumers, not customers.
Yeah. I think in this regard, maybe there's one point that I didn't raise before. Under Australian law, some of the issues, some of the protection that exists in Europe is in Australia consumer protection, but the term consumer is often extended to small businesses. So I have in the meantime quite a few clients who sell. Typically my clients are subsidiaries of German companies, and their Australian company is a distribution company. So they sell to Australian customers, and they're selling plant and equipment. They're not selling, they're not selling really consumer goods. But if you sell goods of a value of less than $100,000, not little, it can be for many areas of the law, it will be a consumer sale. So I sell, I have a lot of clients in the woodworking industry. I sell a big commercial saw for $80,000-$90,000 to a carpenter. That might be a consumer sale for Australian purposes and has various protection rights. So there are a few things, and also conceptually, the choice of law. You have to always understand that the choice of law, you can choose the applicable contractual law, but that never oust mandatory local laws. Yeah? So if I as a German principal have an agreement with an Australian distributor where I have German law apply, it will not change anything in respect of, for instance, consumer law or the competition law in Australia. I still have to abide by that. Yeah, or labeling laws, which Dennis raised. Yeah.
Yes, and I think the same principles apply that Dennis said. It depends on where the market is affected. It doesn't protect you if you're a German company or wherever you are. The question you've got to ask yourself, is my conduct affecting the market in Australia? And if the answer is yes, then you will be bound by the Australian consumer and competition laws.
Yeah, yeah.
Well, thank you very much, Anna. I think that answered your question.